Diyos na mabuti at maaasahan sa lahat ng panahon. Kami ay nanunumbalik sa inyo at lumalapit na may buong pananampalataya upang hingin ang inyong gabay para sa aming sesyon ngayong hapon. Sa kabila ng aming pagkakaiba ng opinyon at pinaniniwalaan, tulungan niyo po kaming magkaunawaan at magtulungan para aming maipagtanggol at mapangalagaan ang kapakanan ng bawat mamamayan. Dalangin namin na sa huling mga araw ng ika-19 na Kongreso, bigyan mo kami ng karunungan at pag-aninaw sa aming mga pagpapasya. Pagkalooban mo po kami ng lakas ng loob at gabayan mo po kaming mga mambabatas na magpakita ng katapangan at katapatan sa aming sinumpaang tungkulin. Manaig nawa ang aming pagmamahal sa Pilipinas upang maitaguyod ang isang mas malakas at mas maunlad na bayan. Ang lahat ng ito aming itinataas sa ngalan ng Ama, Anak at Espiritu Santo. Amen.
Thank you, Senator Nancy Binay. Secretary, will please call the roll.
All call of members, the Honorable Senator Binay, Senator Cayetano Alan, Senator Cayetano Pia, Senator De La Rosa, Senator Ejercito, Senator Estrada, Senator Gatchalian, Senator Go, Senator Antiveros, Senator Lapid, Senator Legarda, Senator Marcos, Senator Padilla, Senator Pimentel, Senator Poe, Senator Revilla, Senator Tolentino, Senator Tulfo, Senator Villanueva, Senator Villar Cynthia, Senator Villar Mark, Senator Zubiri, the Senate President.
With 21 senators present, Chair declares the presence of a quorum. Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the journal of the 52nd session, Tuesday, June 3, 2020, and consider the same as approved.
Any objection? Hearing none. Motion is approved.
Mr. President, I move that we defer the approval of the journal of the 54th session, Monday, June 9, 2025.
Any objection? Hearing none. Motion is approved.
Before we continue, Mr. President, we'd like to acknowledge some guests in the gallery, guests of Senator Joel Villanueva, our new OWA Administrator, Patricia Yvonne Kaunan, guests of Senator Bato de la Rosa, Vice Mayor John Lester Tan of Maramag, Bukidnon, guest of this representation, Congresswoman Jam Baronda of Lone District of Iloilo City, Vice Mayor Love Baronda of Iloilo City, Vice Mayor Velasco of Paete Laguna with the LGU officials, Vice Mayor Juan Ariel Argañosa Jr. with LGU officials of Mayhay Laguna, and Councilor Charmaine Alomolar of FAMI Laguna. Mr. President, I move to consider on third reading of bills the printed copies of which were electronically distributed to the members on June 7, 2025 in compliance with the 3-day rule in the Constitution. With that, I move to consider on third reading Senate Bill number 2987, the bill on the Office of the Chief State Counsel Act. So move, Mr. President.
Before acting on the motion of the Majority Floor Leader, Chair would first like to acknowledge and welcome the visitors and guests mentioned by the Majority Floor Leader who are here present in the Senate. Welcome to your Senate. Is there any objection to the motion of the Majority Floor Leader to vote on third reading the aforementioned bill? Hearing none, motion is approved. Senate Secretary is directed to comply and to proceed to roll call vote.
An act strengthening the legal staff of the Department of Justice, renaming it as the Office of the Chief State Counsel, redefining, expanding, rationalizing, and further professionalizing its organization and appropriating funds therefore. Roll call vote. The Honorable Senator Binay, Senator Cayetano Alan, Senator Cayetano, Senator De La Rosa, Senator Ejercito, Senator Estrada, Senator Gatchalian, Senator Go, Senator Antiveros, Senator Lapid, Senator Legarda, Senator Marcos, Senator Padilla, Senator Pimentel, Senator Poe, Senator Revilla, Senator Tolentino, Senator Tulfo, Senator Villanueva, Senator Villar Cynthia, Senator Villar Mark, Senator Zubiri, the Senate President.
With 21 affirmative votes, 0 negative, 0 abstention, Senate Bill number 2987 is approved on third reading. Majority Floor Leader.
Mr. President, I move to consider on third reading House Bill number 5598, the bill declaring Maasin City and municipalities of Malitbog and Panriburgos as tourism zones. So move, Mr. President.
Any objection? Hearing none, Motion is approved. Senate Secretary is directed to comply and to proceed to roll call vote.
An act declaring Maasin City and the municipalities of Malitbog and Padre Burgos, all in the province of Southern Leyte, as tourism zones. Roll call vote. Honorable Senator Binay, Senator Cayetano Alan, Senator Cayetano Pia, Senator De La Rosa, Senator Ejercito, Senator Estrada, Senator Gatchalian, Senator Go, Senator Tiveros, Senator Lapid, Senator Legarda, Senator Marcos, Senator Padilla, Senator Pimentel, Senator Poe, Senator Revilla, Senator Tolentino, Senator Tulfo, Senator Villanueva, Senator Villar Cynthia, Senator Villar Mark, Senator Zubiri, the Senate President.
With 21 affirmative votes, 0 negative, 0 abstention, House Bill number 5598 is approved on third reading. Majority Leader.
Yes, Mr. President, before we move on to the other items of the agenda, there's some other guests of the gallery. As guests of Senator Bong Revilla, Governor Datu Pax Ali of the province of Sultan Kudarat, Congressman Jolo Revilla, and Congressman Uging Mercado of Southern Leyte.
To the aforementioned guests, welcome to your Senate.
Mr. President, I move that we proceed to the Senate President's designation of Senate conferees to the Conference Committee on the Disagreeing Provisions of Senate Bill number 2534, the bill on the 100 peso daily minimum wage increase act of 2024, and House Bill number 11376, the bill on wage hike for minimum wage workers act. So move, Mr. President.
Any objection? Hearing none, following members are hereby designated as Senate conferees to the Conference Committee on the disagreeing provisions of Senate Bill number 2534 and House Bill number 11376 as follows. Senator Joel Villanueva, Chairperson. This representation, Senator Jingoy Estrada, Senator J.B. Ejercito, Senator Alan Cayetano, Senator Win Gatchalian, and Senator Mark Villar. On the part of the minority, Senator Risa Ontiveros and Senator Coco Pimentel, our Deputy Minority Floor Leader and Minority Floor Leader respectively, are so designated. What is the pleasure of the Honorable Villanueva?
Yes, Mr. President, just to give honor to whom honor is due, it was actually Senator Jingoy Estrada who head the Committee on Labor when this particular measure was passed, and it just so happened that this representation is now the chair of Committee on Labor. But I'm also willing, Mr. President, to just be on the sides of Senator Estrada. We just want to put that on record. Thank you, Mr. President.
What is the pleasure of the Honorable Zubiri?
Yes, Mr. President, being the principal author of that measure, maybe you would consider
Please.
me being part of the bicameral conference committee.
What
you.
does the sponsor say?
Gladly, Mr. President. Gladly, Mr. President.
Thank you, Mr. President.
Thank you, Mr. President.
Chair hereby amends the designation and adds Senator Juan Miguel Zubiri to be part of the bicameral conference committee report on the disagreeing provisions of Senate Bill number 2534 and House Bill number 11376. So ordered. Majority Leader.
Mr. President, I move that we proceed to the Senate President's designation of Senate conferees to the Conference Committee on the Disagreeing Provisions of Senate Bill number 2821, the Bill on Accelerated and Reformed Right-of-Way Act, and House Bill number 6571 on the Right-of-Way Act. So move, Mr. President.
Any objection? Hearing none, in compliance, the chair hereby designates the following members as Senate conferees to the Conference Committee on the Disagreeing Provisions of Senate Bill number 2821 and House Bill number 6571, namely Senator Mark Villar as chairperson, this representation as well as our minority leader, Senator Aquilino Pimentel, Coco Pimentel III. So ordered. Majority Floor Leader.
Mr. President, Senator Ronald Bato de la Rosa is seeking the floor for us. He would like to deliver a privilege speech.
What is the pleasure of the honorable?
Mr. President.
Before recognizing the Honorable De La Rosa, Senator Pimentel is raising his hand. What is the pleasure of the Honorable Pimentel?
Shouldn't we, in good faith, implement the approved motion from yesterday, Mr. President, that at 4 o'clock we should be taking our oath as senator judges, and then we'll give way to the privilege speech, Mr. President. So that was the motion approved by the body yesterday.
Majority Leader.
Yes, Mr. President, we will be honoring that what was agreed upon yesterday, but this is a personal collective privilege, and any member of this August body can just stand up and avail of this collective of this privilege hour, Mr. President.
No, I don't think so, Mr. President. This is a privileged speech. This is a privileged speech. This is not a privileged motion. So my motion is to execute and implement what was agreed upon yesterday. At 4 o'clock in the afternoon, we take our oath.
Senator,
I make of record the time. It's 4:31 p.m. Mr. President.
Senator De La Rosa.
Yeah, Mr. President, it was very clear yesterday that we agreed that before I take my oath as member of the impeachment court, I should have delivered my privilege speech. That's why I made it a precondition to my approval or to my agreement to the motions yesterday that I'm willing to take oath as a member of the impeachment court, provided let me first deliver my privilege speech. And very clear, it was agreed by the minority leader.
No,
yesterday.
Mr. President, no. It was stressed the convening of the court. That was
This representation would want that all matter that arose. Senator Tolentino may proceed.
With the permission of
All members are raising their hands. May I first acknowledge our Majority Floor Leader, Senator Tolentino. Thereafter, our Deputy Minority Floor Leader, Senator Ontiveros. Senator Tolentino may proceed.
With the permission of the gentleman. Mr. President, let me remind the gentleman that yesterday this representation moved to expunge from the records the word agreement, precisely because this representation would want that all matter that arose yesterday should be expressed stipulations coming from the mandate of the Constitution. Yung agreement po siguro inalis na natin to reflect the solemnness of the proceedings yesterday. So, kung ano po yun ang pag-usapan, Mr. President, siguro yung dalawang ginoon na lamang muli ang magkasundo, pero the record should not reflect the word agreement. Yun po lang yung sinasabi ko, Mr. President. Maraming salamat po.
Mr. President,
Senator,
this is important because it's related. So, what I'm asking
Senator Pimentel, you may proceed.
What I'm asking to be enforced is the motion approved already, Mr. President. So we had approved by the plenary. A motion was approved by the plenary. So yun lang.
Senator Ontiveros is recognized.
I second the motion of the minority leader, Mr. President. The motion to implement the approved motion. Napakahirap naman po magpatupad ng ganyan kasimple. Mr. President, under Section 3 of our Rules of Procedure on Impeachment Trials, the presiding officer shall administer the prescribed oath or affirmation to the members of the Senate then present, and to the other members as they shall appear, whose duty it shall be to take the same. So yung pagka wala po o yung hindi pa po pagkasumpa ng ibang mga senador, hindi naman po hadlang sa mga present ngayon at manunumpa ngayon para magsimulang tuparin yung tungkulin namin bilang miyembro ng impeachment court. Kung nais po ng good gentleman from Davao mag-deliver ng privilege speech ngayon, maari namang pong ituloy na po yung pagpapatupad ng agreed motion kahapon, manumpa kaming lahat na iba sa inyo bilang presiding officer, and then pakinggan po natin ang privilege speech ng good gentleman from Davao, at pagkatapos kung nais niya, ay pwedeng manumpa na ayon dito sa ating rules of impeachment, Mr. President. So sinusugundahan ko po yung motion ng minority leader na gawin na po natin yung approved motion kahapon. Salamat po, Mr. President.
Chair would like to make some remarks before acknowledging Senator De La Rosa. there was a prior motion made by the majority floor leader. There is no motion to second as of yet because we first have to dispose of the first motion made by the majority leader with respect to the recognition of Senator Bato. But we note the manifest. We will consider and take note of the remarks of Senator Ontiveros as a manifestation for the meantime. Now, the movement is here. The person who made the motion yesterday, perhaps when I suspend session, you can discuss it. But for the record, there is no attempt whatsoever, and kindly, I hope people will refrain from making insinuations that there is an intent not to proceed with what was agreed upon yesterday simply because of the time. Because I was here at 4 p.m. and I waited until we had enough numbers for a quorum. And we will proceed as scheduled with respect to that. So whether Senator Bato, as will be discussed when we suspend, will speak first, or we will do what is being suggested by the minority floor leader. In either case, both will be done today. So before I recognize the movement, Chair will suspend the session so that you can discuss. Session is suspended.
To play. It's not only a very hot by Mr. President,
Senator Cayetano is recognized.
with the permission of the majority leader and Senator Bato, the minority leader, may I just offer some voice of experience. Actually, sinabi na to ni SP, pero I'll just elaborate. But let me start out by saying, I understand why the minority leader stood up. Yes, minority at mas konti sila, but they have a role to play. It's not only a very important role today, it's an essential role. It's not only a role in our legislative session, it's a role in holding the second highest person in our government accountable. They have fought for that not just yesterday, but the minority leader, despite running for Congress, have continued in Tagalog, tinutukan to. And in fact, I have to apologize to him. Medyo mas tama ka na yung forthwith means agad. Pero tinignan ko na yung Filipino version, isusunod agad. In that context, makikiusap ako sa minority leader. We've been here long enough dun sa atin na 3-4 terms na pag nag-argue kung sinong una, tatagal tayo na 1-2 oras, walang mauuna. So kung gagawin natin yung forthwith today, ibig sabihin isusunod agad. I looked at the rules, no? Sabi po kasi talaga pagka personal privilege, pwede mauna. But ang sabi nga ni minority leader and backed up by the deputy minority leader, we know how important the impeachment court is. So may I ask a further favor indulgence from the minority leader that we allow Senator Bato so that we also do not violate. We're going to violate 1 or 2 things today. Violate the agenda, dahil sa agenda talaga mag-oath taking, or violate our rules, dahil sabi sa rules, anytime pwede kang tumayo sa personal privilege. So may we ask for the indulgence ng minority to to allow Senator Bato to deliver his speech because binanggit niya to sa akin kahapon. Kung ako nagkulang, pasensya na po kayo dahil ang pakiusap niya kahapon, bago mag-oath, magsasalita siya. So if we can allow him, then with the permission of the majority leader, I'll volunteer you to forthwith immediately, agad-agad move na we take our oath as members of the impeachment court. If it's acceptable to the minority leader. It's not the perfect solution, sir, but I hope it's acceptable.
What does the minority leader say?
Basically, Mr. President, we will agree to the suggestion of Senator Alan Cayetano. Pero ito lang yung point ko for those of you still present or serving in the 20th Congress. There is a purpose, meron tayong agenda. So when you are in number 7 for privilege speech, you cannot just stand up and then accelerate the tackling of your item in the session, Mr. President, by just standing up. So ano lang po yun, just an observation. So with that, I willingly give way to our colleague with this important message for us, Mr. President, Senator Bato de la Rosa.
We thank Senator Pimentel, also thank Senator Cayetano. Sana mas madalas-dalas siya dito. Hindi ikaw, Coco, si Alan. And also for the record, I'd like to assure our minority floor leader and deputy minority floor leader that we will, the chair would rather preside over the oath-taking of members of the impeachment court today. Before we adjourn, the clock not with standing to give way to the privileged speech of the Honorable De La Rosa, because the Senate, after all, is a deliberative body. Everyone should be free to say their piece, subject to certain limitations, of course, and we are free to agree or disagree. And if the matter cannot be settled, for it to be put to a vote. If there are no other members who wish to state their piece on the matter, Chair now recognizes Senator Bato de la Rosa. You may proceed, sir.
Thank you, Mr. President. Mr. President, esteemed colleagues, ladies and gentlemen. Imagine a house, Mr. President, an unfinished one that is still being built. Where do we begin? Of course, with solid foundations, a level ground, as well as an honest blueprint. Hindi pwede ang mga shortcut. Hindi pwedeng madaliin. Kung babaliwalain ng mga architects at mga engineers ang mga basic requirements, hindi magiging matibay ang itatayong bahay. Maaari itong magdulot ng panganib, hindi lamang sa mga maninirahan dito, kundi maging sa ibang mga kabahayan sa paligid nito. If any of us happen to discover that the house we were living in was structurally unsound, we would likely scramble to have it retrofitted. We would probably file cases in anger against developers. I doubt any of us would simply shrug our shoulders, saying, andito na tayo hayaan na lang. Now, imagine a house of representatives that built and filed the impeachment complaints against Vice President Sara Duterte. Trabahong inupuan sa simula. At noong papalapit na ang deadline, biglang naging buzzer beater. Mabilisang pinasa sa atin at ngayon tayo naman ang pinipilit at minamadali. Pinapagalitan pa nga. That is your sworn duty. Tama na ang pamumulutika. This is undue delay. Sandali. Bakit kaya sa pagkakataon at pangyayaring ito, Tila madali lang para sa atin ang sabihin, andito na tayo eh. Andyan na nga eh. Mr. President, the House of Representatives are of the belief that they have built a solid case against Vice President Sara Zimmerman Duterte, prompting them to file an impeachment case. But how sound are the foundations of this impeachment case filed against the Vice President? Kagaya po ng konstruksyon ng isang bahay, ang proseso ng impeachment ay kinakailangan na nakatungtong sa isang solidong pundasyon. Ibig sabihin, ang mga arkitekto na pasimuno nito ay may tungkulin na tiyakin na may tatayuan ang kanilang mga akusasyon. Ngunit, ang impeachment ay isang proseso na hindi nakasalalay lamang sa mga arkitekto o mga instigador nito. Sa totoo lang, pinakamadali ang naging gampanin ng HOR sa proseso ng impeachment. Yun ay ang pagbubuo ng mga akusasyon, Mr. President, kahit sino po ay maaring magparatang kung kanino man. Sa bahagi naman po natin, ang pinakamahirap, ang paghusga, ang paggawad ng isang hatol na makatarungan at katanggap-tanggap. Anuman ang nakatuntong sa mahinang pundasyon ay laging may panganib na gumuho. Kung ang isang impeachment case ay minadali at nakasandig sa paghihiganti at pamumulitika, ay maihalin tulad sa isang strukturang itinayo sa gilid ng bangin. Bagamat tungkulin o obligasyon natin sa Senado na mag-convene bilang impeachment court, responsibilidad din natin na maging mapanuri at critical sa impeachment complaint na ipinasa rito sa ating bulwagan. As I usher in my 6th year in the Senate, my 39th year in public service, Mr. President, I can say I have gotten better at spotting irony. What we refuse to let happen to our houses, we seem to have allowed our House of Representatives to do in broad daylight, right under our noses, and at the expense of our institutions' esteemed reputation. With this, Mr. President, my dear colleagues, allow me to express my serious concerns surrounding the constitutionally unsound foundation of the articles of impeachment that the Senate is set to tackle. Article 11, Section 3, Paragraph 2 of the 1987 Philippine Constitution provides that a verified complaint for impeachment may be filed by any member of the House of Representatives or by any citizen upon a resolution of endorsement by any member thereof, which shall be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter, keeping in mind the aforementioned constitutional provision. Recall that on December 2, 2024, the first impeachment complaint against Vice President Duterte was filed before the Secretary General of the House of Representatives. The second and third impeachment complaints were filed on December 4, 2024 and December 19, 2024, respectively. These complaints were each endorsed by members of the House of Representatives. While the Constitution requires that a complaint for impeachment must be included in the order of business within 10 session days, the House of Representatives Rules of Procedure in Impeachment Proceedings require the Secretary General to immediately refer the complaints to the Speaker. Despite this, no action was ever taken by the House on the 3 impeachment complaints filed. Hindi po ito simpleng pagkalimot, Mr. President. Ito po ay tahasang pagsantabi ng kanilang internal rules at constitutional provision. Sinadya po nila na baliwalain ang konstitusyon. Maliwanag po ito sa mga naging panayam kay House Secretary General Velasco. In media interviews, the Secretary General publicly disclosed that the members of the majority of the House of Representatives asked him to withhold the transmittal of the impeachment complaints to the Speaker. Their goal then was to give themselves more time to decide whether or not to file another impeachment complaint. Pinaghintay po ng mayorya ng House of Representatives ang 3 impeachment complaint. May ganyan po ba silang kapangyarihan? Tila po. Ito ay matatawag na grave abuse of discretion. Then, on February 5, 2025, more than 2 months after the first impeachment complaint was filed, the House of Representatives took the fast-track route according to Secretary General Velasco. Kung ang 3 naunang impeachment complaint ay pinadaan sa EDSA, mukhang sa Skyway po ang piniling landas ng House para sa pang-4 na impeachment complaint para maiuwi ito sa Senado. With less than an hour before the close of session of that day, the House of Representatives transmitted to the Senate a verified complaint for impeachment against Vice President Sara Z. DUTERTE, purportedly signed by 215 members of the House of Representatives. My honored colleagues, had the House complied with their own rules and the Constitution, the 3 previous impeachment complaints would have been referred to the appropriate committee by the time the present impeachment complaint was filed and sponsored by the members of the House of Representatives. In other words, Your Honors, the intentional inaction of the House of Representatives allowed its members to purportedly circumvent the 1-year ban enshrined in Article 11, Section 3, Paragraph 5 of the Constitution. Given the glaring circumvention of the Constitution, should we allow impeachment complaints which are constitutionally infirm to be heard and tried by this body? Kung defective po ang foundation ng impeachment complaint, marirepair o marirehabilitate ba ito ng pag-convene ng impeachment court? Hindi po ba mawawala ng saysay ang pag-convene ng Senate as an impeachment court kung malinaw na labag sa konstitusyon ang nais nating itayo? Kaya, ang impeachment ay isang sensitibong proseso. Sa pagsampa pa lamang nito, binabato na agad ang akusado ng putik na kahit maakwit ay tila habang buhay ng nakamansa sa kanyang pagkatao. Pagkatapos ng impeachment, anuman ang magiging hatol, the damage done to the reputation of the accused will forever be irreparable. He or she will never be the same again. Some of the members of this august body may not agree with me and may take a different view as to whether the 1-year ban has been violated by the House of Representatives. To settle this issue, the separate opinion of Chief Justice Renato Espuno in Francisco versus House of Representatives provides this body a direction on the course of action that we may take when confronted with the same issue I laid down. Former Chief Justice Puno said that before the Senate is convened as an impeachment court, the Senate, which has primary jurisdiction over the case, can already decide the question on whether the one-year ban has been violated or not. That is why insisting ako na ma-deliver ito before we convene as an impeachment court. Hindi po natin kailangang hintayin magbagong anyo ang Senado at maging isang ganap na impeachment court. Ngayon pa lamang ay maaari na nating pagdesisyonan ito. Sumunod ba sa saligang batas at sa internal rules ng mababang kapulungan ang impeachment complaint na kanilang ipinasa dito sa Senado? Nasa Senado po ang pagkakataon upang magwasto. Kung minadali ng isuar ang impeachment complaint, bakit kailangan natin itong tumbasan ng kaparihong kawalang pagpapahalaga sa tamang proseso? Madalas po natin sabihin dito sa ating kapulungan, we are men and women of rules. Manatili po tayong ganun, malayo mula sa ingay at impluensya ng kung sino mang may mga personal na interes at pakinabang sa pagmamadaling ipinipilit sa atin. Mr. President, the inaction of the House of Representatives resulted not only in a possible violation of the Constitution, but in another justiciable controversy. It is worthy to note that its new Congress, empowered by a fresh electoral mandate in both the House of Representatives and the Senate, is not bound by the legislative actions of its predecessors. Hindi po natin maaaring pilitin ang mga papalit sa atin sa future Congresses na ipagpatuloy ang anumang ating nasimulan. The Congress cannot pass an irrepealable law. Lahat ay pwedeng baguhin at galawin ng mga sumusunod na mahahalal sa Kongreso. Maari pong hindi sila gumalaw at hayaan lamang na nakatiwangwang ang anumang proceeding na sinisimulan ng mga nauna. When the fourth impeachment complaint was submitted, the 19th Congress was teetering on the brink of a long slumber. The Senate is now being urged to convene with only 2 session days. 20 days remaining before the 19th Congress closes. Hindi man po ako abogado, alam ko pong walang kaso, mapasibil, administrative o kriminal na dinidinig sa loob lamang ng isang buwan. Naghihingalo na po ang buhay ng 19th Congress. Bakit po natin ipipilit pa kung ang pintuan ng 20th Congress ay malapit nang magbukas? Malinaw naman po sa ating Rules of Procedure on Impeachment Trials. Kailangang isumon ang person impeached para paharapin sa Senado. Kailangan din siyang bigyan ng 10 araw para mag-submit ng kanyang answer. 5 araw naman ang ibinibigay sa mga prosecutor para mag-file ng kanilang reply. Kaya po, kahit mag-convene ng impeachment court bukas, sumon at pagtanggap lamang sa pleadings ang kayang magawa ng 19th Congress. Sigurado na po tayo na ang trial kasama ang pagrepresenta ng ebidensya ay magaganap sa 20th Congress, kung saan bago na po ang komposisyon ng Senado at mababang kapuluan. Because of the change in members, questions are being raised on the jurisdiction of the Twin Congress to carry on with an impeachment trial commenced in the previous Congress. Should the 19th Congress convene an impeachment court, what assurance exists? Without such assurance, any efforts by the 19th Congress would constitute a significant waste of government resources. Even the authority of the House of Representatives to continue prosecuting is being questioned since the said complaint was filed by a House of a different composition. In fact, some of those who signed the complaint failed to secure a seat in Congress in the recently concluded elections. Mukhang kailangan po natin ng positive act from the 20th Congress House of Representatives na kanilang itutuloy ang impeachment complaint na ginawa ng 19th Congress House of Representatives. Mr. President, the constitutionally given power and mandate of the Senate to try and decide all cases of impeachment is an immense responsibility that must be exercised in good faith, with sincere intention to fulfill a solemn oath, not with haste, but with careful circumspection, mindful of both the political and legal nature of the exercise. Ang impeachment ay isang proseso na hindi lamang mag-aalis sa pwesto ng isang mataas na opisyal ng pamahalaan. Ito ay isang armas laban sa sinuman na hindi umaayon sa kagustuhan at mga interes ng mga kaaway sa politika. Ito ay apoy na hindi lamang nakapapasok, kundi may kakayahan na tupukin at sunugin hindi lamang ang isang bahay, kundi isang buong komunidad. Mapanganib ang impeachment sa kamay ng mga mapagsamantala. Inilalagay ang impeachment para protektahan ang taong bayan, hindi isakdal at hiyain ang kumakatawan sa kanila. In the 2012 case of Chief Justice Renato C. Corona versus Senate of the Philippines, the Supreme Court declared impeachment, described as the most formidable weapon in the arsenal of democracy, was foreseen as creating divisions, partialities, and enmities, or highlighting pre-existing factions, with the greatest danger that the decision will be regulated more by the comparative strength of parties than by the real demonstrations of innocence or guilt. The House of Representatives, in transmitting the articles of impeachment to the Senate at the last hour, and after refusing to act for over 2 months on 3 previously filed complaints pending with the House Secretary General, has instead placed the Senate in a tight and impaired position where any decision, action, or inaction on its part will be put into question. An acquittal, conviction, or even the propriety of proceeding with trial will be hounded not only by legal or constitutional questions, but by accusations of extreme bias, partiality, and lack of sufficient deliberation. Lagi kong sinasabi, Mr. President, hindi ako abogado. Nevertheless, this cannot disqualify me from speaking against possible constitutional blunders. Hindi kailangan maging engineer para masabi ng isang tao na unlivable at hindi ligtas ang isang bahay o building. Alam nyo, alam natin, kung kailan matibay at pulido ang pagkakagawa katulad ng isang bahay na bato. Alam din natin kung kailan hindi. When the floor starts to crack, when the walls begin to shift, and when leaks appear where there should be none, there and then, Mr. President, there and then, forthwith, we say, this was not built well. Gayon din sana sa impeachment case na ito. The cracks and holes have begun to show. Alam nating may mga tanong na hindi pa nasasagot, lalo na patungkol sa constitutional soundness ng nasabing impeachment complaint. It is my humble opinion then, Mr. President, that with this knowledge must come swift and intelligent action. Kung gaano natin kabilis i-condemn at ipagiba ang mga strukturang hindi ginawa ng maayos, ganoon din dapat tayo kabilis umaksyon kung ang nalalagay sa alanganin ay ang ating konstitusyon. In the spirit of true action, therefore, allow me to end by moving. I respectfully move that in view of its constitutional infirmities and questions on the jurisdiction and authority of the 20th Congress, the verified impeachment complaint against Vice President Sara Duterte be dismissed. Mr. President, since I have still the floor, I would like to call Senator Bongo. Mr. President.
Mr. President, will the good gentleman yield the floor for a few remarks as part of the privilege hour availed by Senator De La Rosa?
Yes, Mr. President. No problem with me. Thank you, Mr. President.
Mr. President, I agree with the speech of Senator Bato De La Rosa. Ang gusto nating kalabasan ng paglilitis na ito ay justisya.
Senator Go, before you proceed, Chair has not yet recognized you. Session is suspended. chair would like to first state the parliamentary situation. After the privileged speech of the Honorable Bato, he asked that the chair recognize Senator Bongo to deliver a seconding speech to the motion he made at the end of his privileged speech. The chair has not yet acted on that motion and has not yet recognized Senator Go. And before the chair declared a short suspension, two members raised their hand to be acknowledged and be heard, and the chair intends to listen to them first before acting on the pending motion. Senator Ontiveros first, and then Senator Villanueva. You may proceed, ma'am.
Maraming salamat po, Mr. President. Immediately after the speech of the good gentleman from Davao, I move that any interpellation or any action, any seconding speech on the privileged speech be suspended momentarily after his speech to allow us to take our oath, which was the subject of the approved motion yesterday, and again, which was the subject of the approved motion yesterday, which is an offshoot of a question of privilege, which takes precedence over all motions. So I restate my motion, Mr. President, to momentarily suspend any action, whether interpellation or seconding speech on the privileged speech of the good gentleman from Davao, para sa wakas bigyang daan yung inaprubahan nating motion kahapon na manumpa na po kaming I still have the floor. I have the floor, Mr. President. I have the floor, Mr. President, to make way for taking of the oath before the presiding officer.
What is the point of order of Senator Marcos?
Yes, thank you very much, Mr. President. And I'd just like to reiterate that I wasn't being rude, but simply recognizing the fact that the point of order takes precedence over all other motions. Also, that there is, in fact, a motion already pending on the floor, already acknowledged as well by our majority leader, which requires a vote.
Duly noted, but the chair has not yet acted on the motion and there has been no objection as of yet. We will address the motion of Senator Bato, as the chair said earlier, after we hear from Senator Villanueva now.
With all due respect, Senate President, the Deputy Minority Leader is proposing yet another motion on top of the pending motion.
The chair
That
will
is not allowed.
The chair has not yet acted on that motion and will not yet so act on that motion. And we'll be making a ruling after we hear from all of those who raised their hands earlier. So, with the indulgence of Senator Marcos, can we hear from Senator Villanueva?
Thank you very much.
And then the chair will rule on the pending matters. Senator Villanueva is recognized.
Thank you very much, Mr. President, distinguished colleagues. Mr. President, if I hear it right, the movant made a motion to dismiss the impeachment complaint, if I heard it right, Mr. President. Mr. President, may I just place on record that this representation respectfully object to that motion. Mr. President, for various reasons, Mr. President, that this representation would like to raise on the floor, Mr. President. One, Mr. President, is that the Senate, as a legislative body, and at this point in time, we have not yet convened, Mr. President, as an impeachment court. And therefore, Mr. President, this representation believes that we have no constitutional authority as legislative body to dismiss an impeachment complaint. Let me quote the Constitution under Article 11, Section 3, Number 6 of the 87 Constitution. The Senate's role is expressly limited to trying and deciding all cases of impeachment after the House of Representatives has transmitted a valid articles of impeachment. Mr. President, the Senate, in its capacity as a legislative body, does not possess the constitutional authority to unilaterally dismiss an impeachment complaint. And under the constitutional framework, the Senate assumes a distinct and separate function when acting an impeachment court. Please don't get me wrong, Mr. President. In fact, a lot of the statements made by Senator Bato de la Rosa, I share. I share the sentiments, Mr. President. In fact, Mr. President, when the impeachment case was filed or the articles of impeachment were transmitted here in the Senate an hour before we adjourned, Mr. President, before our break, a week after, more than 380 pages, Mr. President, of annexes ang dumating po, Mr. President. So, dun pa lang, Mr. President, I agree with Senator Bato's statement na somehow minadali or tignan natin. But again, Mr. President, my only concern here is that we have not yet convened as an impeachment court. We can probably dismiss this or even entertain the motion if we are already acting as an impeachment court. Let me go to my other point, Mr. President. The Senate lacks the power to dismiss an impeachment complaint and has no constitutional duty to proceed to trial. And that's why, Mr. President, if you recall yesterday, this representation mentioned that notices are very important when the minority leader made a motion yesterday that he wanted to stop our legislative work and proceed with the convening of the impeachment court. And he made mention about the calendar of activities, kung kailan magsisimula, ano yung timelines, etc., Mr. President. And that's why I objected again, Mr. President. So in the name of consistency, Mr. President, let me again state for the record, the power of initial determination belongs solely to the House of Representatives. You and I, Mr. President, were members of the House for quite a long time. And we talk about it all the time, that it is the sole power of the House to determine kung yung impeachment or articles of impeachment na itatransmit sa Senado ay mayroong required votes, etc., etc., at ang tanging sole authority naman ng Senado is to act as an impeachment court, not, Mr. President, not as a gatekeeper of the complaint's sufficiency. Further, Mr. President, it bears emphasis that the framers of the Constitution intended a clear division of roles. House initiates and the Senate tries and decides. Again, Mr. President, I am not even going to say whether or not I will support the motion of our dear colleague, Senator Bato de la Rosa. I'm just saying, Mr. President, that it should be posed, Mr. President, in the impeachment court. Last but not the least, Mr. President, the Senate as a legislative body, or even when it sits as an impeachment court, Mr. President, ito po yung ating posisyon, may not dismiss the impeachment complaint due to change of Congress. Impeachment, Mr. President, is a political discretion. It's not a political discretion, but a constitutional mechanism rooted in the principle that public office is a public trust. Alam na po natin lahat yan bilang mga lingkod bayan. Yung sinasaad ng 87 Constitution, which provides public office, is a public trust. Public officers and employees must at all times be accountable to the people. This duty, Mr. President, is not suspended, nullified, or extinguished by the expiration of the legislative calendar or the transition to a new Congress. But again, I also believe and support the statements made a while ago by Senator Bato de la Rosa. yung pong functus officius ng Senado, hindi ho applicable sa atin dahil kalahati nga ho sa atin dito, magiging parte pa rin ng impeachment court, parte pa rin ng Senado. Pero doon po sa House, hindi na. So kailangan talaga na malaman natin kung sila'y interesado pa doon sa impeachment na kanilang i-file. Mr. President, just this morning, if I don't know if this morning or last night, I saw an article. I'm not sure if it's Justice Ascuna or Attorney Divina saying that the House must actually do something, whether at least, the very least, is to pass a resolution authorizing, Mr. President, their representatives, their prosecutors, that they are indeed have the blessing of the 20th Congress. Kaya po, muli, Ginoong Pangulo, ang aking pag-object doon po sa motion ng ating kagalang-galang at kaibigan, Senator Bato de la Rosa, ay base po sa mga binanggit ko po na mga reasons. Maraming salamat, Ginoong Pangulo.
Before the chair makes a ruling, Senator Bato.
Yes, Mr. President. I just would like to share this august body the basis for my motion. According to Chief Justice Renato Puno in Francisco versus House of Representatives, a number of things can be done before the Senate is convened as an impeachment court. For example, the Senate, which has the primary jurisdiction over the case, can decide the question of whether the one-year ban has been violated or not. Likewise, the Senate can decide whether the complaint on its face has any legal basis.
Mr. President, if I may,
So as not to belabor the point, Chair would like to state the parliamentary status and make a ruling. Again, to reiterate, Senator Bato, after the end of his privileged speech, made a motion, but before the Chair could act on that motion, he asked for the recognition of Senator Bato, who wanted to second the motion of Senator Bato at the end of his speech. Before the Chair could act on that motion and recognize Senator Bato, Senator Ontiveros and Senator Villanueva signified their intention to speak. Senator Ontiveros made a motion to suspend further consideration of the matter at hand so that we can proceed to take our oaths. And then Senator Marcos raised the point of order that there are too many pending motions on the floor and that we should dispose of them, as correctly pointed out by her. Senator Villanueva objected to the motion of Senator Bato. With the permission of Senator Villanueva, hindi ko po ituturing na objection yung inyong sinabi dahil ayon mismo sa inyo, hindi naman kayo tutol doon sa motion ni Senator Bato, kanya lamang. Gusto nyo at sa paniniwala nyo, pwede lamang ito magawa kapag tayo ay isang impeachment court na at hindi bilang isang Senado. Ayon sa authority na kinukot ni Senator Bato, may opinion, may concurring opinion. Si dating Chief Justice Puno na pwedeng itong gawin ng Senado. Concurring and dissenting opinion siya sa pagkakaalala ko sa Francisco. With the permission of the gentleman on the floor, the chair is of the considered view that and takes well the position of Senator Villanueva. We will act on the motion of Senator Bato, but as an impeachment court.
Yes.
We cannot act on the motion of Senator Bato unless we take our oaths as members of the impeachment court. Therefore, once the impeachment court is after we take our oaths and we convene the impeachment court, Senator Bato can reiterate his motion, Senator Go can then second his motion if at all, and we will proceed to dispose of such motion after we hear from everyone who wants to speak on the matter.
Mr. President, just to clarify your statement, Mr.
Senator
President.
Villanueva, before I make a ruling.
Yes, Mr. President, you were saying, Mr. President, because the way I look at it, you are saying, Mr. President, that in order for us to dispense with the motion of Senator Bato, we would have to convene.
We would have to convene the impeachment,
impeachment
court,
court.
as you said earlier.
Yes, Mr. President, I thank you for that. But in order for us to convene again, Mr. President, and just for the information of our law students and those who wanted to learn from these proceedings, Mr. President, this representation made a statement yesterday that we cannot proceed with the convening of an impeachment court unless we issue notices, Mr. President. And I made mention about it because the minority leader's motion yesterday was to convene and at the same time talk about the calendar of activities, Mr. President. And so I would just like to put that on record, Mr. President, because we are not going to discuss the agenda of the, if we convene the impeachment court. Is that the case, Mr.
The
President?
matters to be discussed requiring notice included the proposed schedule of the
Yes.
impeachment complaint, which needed the presence of the parties. However,
Because if we can do it by ourselves, for example, Mr. President, just approving our rules on impeachment, issuing summons, we don't need to issue notices. Is that correct, Mr. President?
however, there are certain matters that the court can do motu proprio,
Yes.
and it would perhaps include these matters, which is up for the consideration of the court once we convene. So again,
Mr. President, thank you.
Senator Bato is recognized.
Thank you, Mr. President. I just would like to counter the statement of Senator Joel Villanueva, Mr. President. You know, as the good Senate President mentioned yesterday, the Senate dismissed the impeachment complaint against Ombudsman Gutierrez after she resigned without convening the impeachment court. Therefore, the Senate, without convening into impeachment court, is not prohibited from dismissing the impeachment case, Mr. President. It's very clear. When you say iba, iba nga kasi nag-resign. Pero still, the capacity or the legality of the action of the Senate not convened as an impeachment court was not questioned. So therefore, considering this case, I think we can do the same, Mr. President.
Mr. President, if I may, Mr. President, this is a reaction, Mr.
With the
President.
permission of the gentlemen who have the floor, Chair will suspend for a few minutes because you will most likely simply engage in a debate because clearly you both have different positions on the matter. Session is suspended. Chair would like to make a ruling with the permission and indulgence of the gentleman who had the floor earlier. Again, to reiterate the parliamentary status. It is the opinion of Senator Villanueva that we can only act on the motion of Senator Bato if we convene if we constitute ourselves and convene as an impeachment court. It is the opinion of Senator Bato that we can act on the matter sitting as a Senate in plenary. While both are considered, while the chair considers both legal and possible and probable, the chair prefers that we convene as an impeachment court first before we act on the motion of Senator Bato, and after we approve the rules, that will be the first item in the agenda of the court, after being seconded by Senator Go.
Point of clarification.
Yes, Majority Leader.
With the permission of Senator Bato, would that mean, Mr. President, that the motion pending right now would have to be reiterated before the impeachment trial court by the movant, Mr. President?
Yes, that is correct, Your Honor.
And,
Given the position of the chair, Senator Bato.
Yeah, with the indulgence of the Senate
Yes,
President,
please.
may I respectfully request that before the ruling is made, or you have made the ruling already, so I therefore object momentarily your ruling, because I have to consult my
Session is suspended.
colleague.
Session is suspended for a minute.
okay.
Mr. President.
For the last time,
Mr.
the
President.
chair will now state the parliamentary status. Senator Bato made a motion that Senator Go wanted to second. Senator Joel took the position that we should sit as an impeachment court before we can act on that motion. For the chair, the suggestion of Senator Villanueva is well taken, while recognizing also the position of Senator Bato, although the chair prefers the position of Senator Villanueva that we first convene as an impeachment court before acting on the motion. So the chair hereby rules that in order to act on the motion of Senator Bato, we should first convene as an impeachment court by taking, by this representation, presiding over the oath taking of the members of the Senate, where the first item in the agenda of the impeachment court, after we approve our rules, will be to act on the motion of Senator Bato, listen to the seconding speech of Senator Go, and perhaps the seconding speech also of Senator Padilla or whomsoever would like to second the motion, allow the members to speak before dividing the House. Therefore, Chair will suspend session in order to allow the members to kindly don your robes, impeachment robes, so that the chair can subscribe the oath to the members of the impeachment court so that we can convene the impeachment court and do the items rather that the chair mentioned earlier. Senator Bato.
Mr. President, I think I got the point of the good minority leader. And I would like to expound this, Mr. President, that after we take oath, Mr. President, can we go back as a Senate, not as an impeachment court, para pagbigyan na makapagsalita yung aking mga kasamahan, si Senator Bungo at si Senator Robin Padilla, not as an impeachment court, but as a Senate, Mr. President. Just reverting back our status after taking an oath.
Mr. President, may I make a suggestion?
Senator Alan is recognized.
Sir, konting patience po from someone na mas madalas makipag-away kaso sa ipagbati ang ating mga kasama. May I propose this? I disagree with Senator Bato in dismissing the case. I agree with him based on former Chief Justice Puno's statement. And naniniwala kasi ako pag jurisdiction, titignan muna natin sa body. Having said that, tama ang ruling ng Senate President that either or, which is better. The only reason I think that better yung impeachment court because we will take an oath of political neutrality. While there's no test for that, konsensya na natin lahat once we take our oath. May I suggest, because I think the konting disagreement between my two brothers, Brother Joel and Brother Robin, is may feeling na hindi natin pinapasalita yung iba. May feeling naman ng minority dahil mas konti sila ay sinusupil ang kanilang karapatan isulong ang isang constitutional duty. May feeling naman yung iba dito sa likod na bakit masusunod yung minority. But I think, Mr. President, when we convene as an impeachment court, am I correct? Senator Bongo and Senator Robin and anyone who wants to speak on the issue of dismissal or any other motion will be able to speak and can move that their statement also be reflected in our session after or tomorrow.
That is correct, Your Honor.
So that they don't have to repeat it twice. Because the problem, Senator Bato is not an attorney, but he's talking like an attorney. So Senator Batorney, my humble opinion is mas mabuting mag-oath at doon because the statement of Senator Bongo and Senator, ako mismo I wanna argue bakit hindi dismiss. If I argue it here now, then I will have to argue again in the impeachment court. But if we argued in the impeachment court, then move that it also be in the records of the legislative session, then we have both of best worlds, if it's acceptable to you. Yeah. If it's acceptable to you, Brother Robin. Yeah. And to the minority leader. Thank you, Mr. President.
The point of Senator Cayetano, accepted by the members so mentioned, is well taken. Chair now again reiterates its ruling. The chair will suspend the session until 6 p.m. This evening in order to afford... Gaano katagal ba nyo kailangan magbihis? Huh? Forthwith, di ba?
6:15 probably, Mr. President.
Chair hereby orders that session is suspended until 6:15
Thank you, Mr. President.
to afford our members time to don their impeachment robes in order for the members rather, to subscribe. That is your option, to subscribe to the oath, approve the rules, and dispose of the motion of Senator Bato. So ordered, session is suspended until 6:15. Pursuant to Article 11, Section 3, Paragraphs 4 and 6 of the Constitution, the Senate is now constituted and convened as an impeachment court, and the impeachment trial of Vice President Sara Zimmerman Duterte is hereby declared open and called to order. At this time, the chair will preside the oath to the senators in the chamber in conformity with Article 11, Section 3, Paragraph 6 of the Constitution. What is the pleasure of the Honorable Marcos?
Yes, Mr. President. May I place on record that I make this oath ad cautelam without prejudice to the resolution of jurisdictional issues as well as issues pertaining to the validity of the impeachment complaint or to the filing thereof, if any. Thank you.
Duly noted and entered into the records. What is the pleasure of Senator Padilla?
Gusto ko lamang din pong mailagay sa talaan na ako po ay manunumpa pero meron pong reserbasyon. Yun lamang po.
Duly noted and entered into the records. May I now request everyone to please rise. Raise your right hand and repeat after me. I, please state your name. Solemnly swear that in all things appertaining to the trial of the impeachment of Vice President Sara Zimmerman Duterte, now pending, I will do impartial justice according to the Constitution and the laws of the Philippines. So help me God. You may take your seats. The clerk will now call the roll.
Case number 003-2025 in the matter of the impeachment trial of Vice President Sara Zimmerman Duterte. Call of Senator Judges. Senator Binay, Senator Cayetano Alan, Senator Cayetano Pia, Senator De La Rosa, Senator Ejercito, Senator Estrada, Senator Gatchalian, Senator Go, Senator Ontiveros, Senator Lapid, Senator Legarda, Senator Marcos, Senator Padilla, Senator Pimentel, Senator Poe, Senator Revilla, Senator Tolentino, Senator Tulfo, Senator Villanueva, Senator Villar Cynthia, Senator Villar Mark, Senator Zubiri, the presiding officer.
With 23 senator judges present, Chair hereby declares the presence of a quorum. Before we take up the matter at hand as earlier agreed upon when the Senate was still sitting in Chair would like to first adopt our rules. Chair hereby adopts Resolution number 39 of the Rules of Procedure on Impeachment Trials, Rule 6 of which provides that the provisions of the Rules of the Senate and the revised Rules of Court shall apply suppletorily whenever applicable. As such, the following issuances of the Supreme Court shall likewise apply suppletorily to the current matter on the impeachment of Vice President Sara Duterte, namely, the 2019 amended Rules of Civil Procedure, Rule 1 to 34, except Rule 5, Rule 13 as amended, by AM number 1037 SC-AM number 1194 SC, B, 2019 amended Rules on Evidence, C, AM number 3-1-09 SC guidelines to be observed in pre-trial and use of deposition discovery measures, Part 1A1 to 9, except provisions on mediation and amicable settlement, D, AM number 1037 SC, AM number 119-4 SC guidelines on electronic filing of lower courts, AM number 1288 SC Judicial Affidavit Rule, except Section 9, and F, such other relevant rules and issuances. It is to be noted that we did not change any of the provisions of the rules of procedure because there is already a pending impeachment complaint and the chair would not want to change the rules in the middle of the game, so to speak. However, the updated amended rules of court, as discussed and mentioned and enumerated earlier, shall apply given the suppletory application of the rules of court. Is there any objection? There being none, the aforementioned rules are hereby adopted by the impeachment court. Proceeding now to the matter at hand as earlier agreed upon and discussed by the Senate sitting in plenary. What is the pleasure of Member Judge Tolentino?
Mr. President, for the record, Mr. President, Mr. Presiding Officer,
The gentleman may proceed.
in view of the convening of the impeachment court, I move that the Committee on Rules be discharged with the previous referral of the subject impeachment complaint, considering that the plenary itself, acting as a body, has initiated and ratified the formation of the impeachment court through a direct act. It is therefore submitted that there is no further necessity for a committee report to be submitted, debated, or adopted in relation thereto. I so move, Mr. President.
Any objection to the motion? Hearing none, the Committee on Rules is so discharged as indicated by Member Judge Tolentino. Chair now reiterates the earlier agreed upon matter to be taken up once we have convened as an impeachment court, and for this purpose, the Chair would like to recognize Senator Judge Bato de la Rosa to kindly reiterate his motion, and thereafter, Senator Judge Go to second his motion. Senator de la Rosa is recognized. You may proceed, sir.
Thank you, Mr. Presiding Officer. Sir. So I would reiterate my motion. The
Kindly
motion
restate the motion you made earlier while the Senate was sitting in plenary session.
Yes, Mr. President. In the spirit of true action, therefore, allow me to end by moving. I respectfully move that in view of its constitutional infirmities and question on the jurisdiction and authority of the 20th Congress, the verified impeachment complaint against Vice President Sara DUTERTE be dismissed. I so move, Mr. President. Mr. Presiding Officer.
Senator Go is recognized for his seconding speech. Rather, Senator Judge Go is recognized for his seconding speech.
Mr. Presiding Officer, I just wish to give my remarks and second the motion of Senator Judge Bato de la Rosa. I agree with the motion of Senator Judge Bato. Ang gusto nating kalabasan ng paglilitis na ito ay hustisya, hindi politika. Mararating lang natin ito kung masasagot ang mga katanungang na hindi nabibigyan ng linaw hanggang ngayon. Kung kaya't sana naman, pag-aralan natin ito ng mabuti. Tama na hindi dapat ito patagalin, pero hindi rin dapat ito madaliin. At the very least, pag-aralan natin ito ng mabuti. Baka naman maaari natin itong ibalik o i-remand muna natin. Tama naman po ang accountability. Huwag lang pong politikahin. May tamang proseso ang impeachment. Dapat pag-aralan natin ito ng mabuti. Under Article 11, Section 3 of the 1987 Constitution, a verified complaint for impeachment may be filed by any member of the House of Representatives or by any citizen upon a resolution or endorsement by any member thereof, which shall be included in the order of business within 10 days and referred to the proper committee within 3 session days thereafter. On December 2, 2024, the first impeachment complaint endorsed by members of the House of Representatives was filed before the Secretary General of the lower house. Second and third impeachment complaints were filed in the succeeding days, duly endorsed by members of the House. Under Section 3 of the House Rules of Procedure in Impeachment Proceedings, a verified complaint for impeachment shall be filed with the Office of the Secretary General and immediately referred to the Speaker. Despite this rule, Mr. Presiding Officer, the 3 impeachment complaints filed were never referred to the Office of the Speaker. Instead, a 4th verified impeachment complaint signed by more than 200 congressmen, which now constitutes the articles of impeachment, was transmitted to the Senate. This brings into question the legality of such move when the Constitution provides that no impeachment proceeding shall be initiated against the same official more than once within a period of 1 year. Para sa ordinaryong mamamayan, at lalo na sa aming mga binigyan ng tungkulin na maging senator judge sa paglilitis na ito, this opens up a lot of questions. At ang iniiwasan natin ay yung magpapasya tayo sa isang bagay na makakaapekto sa buhay ng bawat Pilipino. Makakaapekto sa trabaho natin na makatulong sa tao. Tapos hindi naman pala dumaan sa tamang proseso. Yes, we are senator judges tasked to decide on this matter, and we took an oath to be impartial. But this matter, whether it went through the right process or not, should be first decided upon and settled with no question prior to that. We are all for accountability. In fact, maganda nga sana mapakita ng accused at ng accusers kung may ebidensya ba o wala. Pero bilang mga mababatas, dapat siguraduhin alinsunod ito sa batas at tamang proseso. Dapat hindi na circumvent ang batas. Dapat nasunod ang due process at ang rules. Hindi pwedeng shortcut. Justice delayed is justice denied, and justice conducted the wrong way is no justice at all. Anong nangyari sa 3 naunang impeachment complaints? Bakit hindi ito agad na-refer sa Speaker's Office? Bakit hindi ito isinama sa order of business within 10 session days? At bakit hindi ito ini-refer sa tamang komite within 3 session days after its inclusion in the order of business as mandated by our Constitution? Tila dinribo lang ito at hindi pinaandar ang shot clock. Parang hindi po ma-technical sa oras. Sa basketball nga, hindi pwedeng puro dribble lang. May shot clock po yan. At may oras na dapat mong obserbahan. Pangalawang issue na dapat bigyang linaw ay kung maaari bang tumawid ang impeachment case sa 20th Congress. This is the first time in our history that an impeachment case was filed nearing the expiration of a legislative Congress. The reality is, we do not have enough time to finish the impeachment trial this Congress. Mag-aabot na po ang 19th at 20th Congresses at magkakaroon na ng new set of senator judges by June 30. Maging tayo, hindi magkasundo kung paano bang tumawid ito sa next Congress o hindi. Mr. Presiding Officer, ilan lang po ito sa katanungan na legality na hindi pa nasasagot. Mayroon pa pong pending sa Supreme Court challenging the legality of the impeachment case. Baka masayang lang ang oras natin dito if in the end, this complaint suffers from constitutional infirmities. Let us focus on what is important for our people that we serve. Hustisya sa tamang paraan at serbisyo na makakatulong sa mga Pilipino. Yun po ang kailangan ng taong bayan. Yun ang dapat pagtuunan ng pansin. Mr. Presiding Officer, para sa akin, mas mabuting unahin natin ang tunay nating trabaho. Ang pagseserbisyo sa taong bayan, maraming nasasayang na oras sa isyong ito na hindi naman mapapakinabangan ng ordinaryong Pilipino. This issue has already been too divisive. Ilang buwan na po. Mag-focus sana tayo sa pangunahing mandato ng legislatura, ang gumawa ng mga batas at magsulong sa mga programa na tunay na tutugon sa mga pangangailangan ng ating mga kababayan, lalong-lalo na po yung mga mahirap at walang ibang malalapitan kundi ang gobyerno. Marami pa pong mga pending bills pa po hanggang ngayon na hindi pa natin natatapos with one working day na lang po. Baka hindi pa po may papasa. At ito po'y mapapakinabangan ng mga kababayan natin. Dapat yan po ang ating unahin. As raised by some of our colleagues yesterday, that in as far as the impeachment case is concerned, based on the results of the recent midterm elections, I believe the Filipino people have decided at ang kanilang desisyon, mas gusto po nilang tutukan natin ang trabaho at serbisyo. Tama na, tigilan na natin ang pamumulitika. 3 taon na lang po matatapos na ang termino ng Vice Presidente. Election na naman at antayin nyo lang sana. Ang importante sa ating mga kababayan ay may pagkain sa kanilang hapagkainan. May matibay na healthcare system na kayang tumugon sa pangangailangan ng may sakit, disenteng trabaho at marangal na pagkakakitaan, di kalidad at abot kayang edukasyon at ang katiyakan at panatag na ligtas silang makakauwi kahit sa gabi. Hindi naman nakakain itong impeachment. Sana pwede ninyong ikonsidera at the very least, bago tayo maglitis dito, siguraduhin muna natin na nasa tama na prosesong tinahak natin dito. At the very least nga, sabi ko, marahil pwedeng ibalik o i-remand muna na ito sa pinagmulan sa House of Representatives dahil marami pang ang katanungan ang legally hindi nasasagot. Mas mabuting siguraduhin natin na sumunod sa proseso ang anumang kaso na ating diringgin para hindi masayang ang ating oras. Sang-ayon po ako na hindi natin ito dapat patagalin. Kahit si Vice President Sara DUTERTE gusto naman harapin ang kaso, ngunit wala ring dapat may gusto na madaliin po ito. Paano kung magsimula na tayo ngayon at magdesisyon ang Supreme Court na unconstitutional ang ginawang procedure ng House of Representatives? Paano kung sabihin nila na hindi pwedeng tumawid sa 20th Congress? Ano ang magiging aksyon natin? This puts us in a possible conflict with the decision of the Supreme Court. We must be prudent about this matter. Mr. Presiding Officer, I just want to reiterate, hindi ko po tinatalikuran ang aking sinumpaang mandato. Tungkulin ko yan as Senator Judge kahit araw-araw tayong maglitis dito. But we would also be remiss of our duty kung hindi natin siguraduhin na dumaan ito sa tamang prosesong nakasaad sa ating konstitusyon. At kilala ko po ang mga Duterte, Mr. Presiding Officer. Hindi sila tumatakas sa accountability, hindi sila tumatalikod sa hamon ng buhay, hindi sila tumatalikod sa kanilang tungkulin. Maraming beses nang sinabi ni dating Pangulong Duterte na handa nga siyang sumagot at harapin ang mga inaakusa sa kanya, pero dito po sa ating bayan, hindi sa ibang bansa. Nabanggit din po ni Vice President Sara Duterte na handa siyang harapin ang impeachment case laban sa kanya. Hindi ito issue ng pagtakas sa accountability. Ang gusto natin dito, siguraduhin na nasunod ang tamang proseso. We must respect and abide by the procedure laid out in our Constitution. Hindi pwedeng mamili lang tayo ng mga provision na ating susundin. We are all bound to the rule of law and we must follow due process. That is all, Mr. Presiding Officer.
Thank you, Senator Go. Before Senator Ontiveros, Chair would like to first acknowledge Senator Padilla. What is the pleasure of Senator Judge Padilla?
Maraming salamat po, Tagapangulong Pinunong Kukom. Mga mahal kong hukom, alam ko po na napakainit at napakamabigat ang hangin dito sa ating bulwagan. Punong-puno ng tensyon, palaisipan, pero habang abala po tayo sa politika, maraming mahalagang panukala ang hindi nabibigyan ng pansin. Mga panukalang batas na hindi tungkol sa kapangyarihan, kundi tungkol sa buhay, sa sakit, sa gutom, sa karapatan ng manggagawa. Tulad na lamang po ng medical cannabis bill. Hindi po ito usaping droga. Ito'y usaping dignidad. Araw-araw may mga batang may epilepsy, may mga cancer patients, may mga nanay at tatay na umiiyak sa sakit, humihingi ng legal na lunas. Nandito na po ang solusyon, pero pinapatagal pa natin. Gaano ba katagal natin hahayaang magdusa ang kapwa natin? Isa pa po, ang mga panukala ukol sa pagtataas ng minimum wage ng mga manggagawa sa pribadong sektor. Hindi po nagpapahinga ang presyo ng bilihin. Ang pamasahe, pagkain, renta, lahat po ay tumataas. Pero ang sahod, naiiwan. Kailangan po nating ipaglaban ang manggagawang Pilipino. Ibigay na natin ang nararapat para sa kanila. Isa pa po, ang Revised Cooperative Code Bill na nakapasa na sa ikatlong pagbasa sa mababang kapulungan at pinagdidiskusyonan pa rin sa komite sa Senado. Ito po para sa mga magsasaka, mangingisda at maliliit na negosyante. Pinal na sana, isang boto na lang, pero naisang tabi pa. Sila po ang bumubuhay sa probinsya. Sila rin ang tunay na haligi ng lokal na ekonomiya. Bakit natin sila pinaghihintay? Mga mahal kong kasama sa Senado, unang-una na po ang aking BFF. I love you, pare. Alam kong may kinakaharap tayong seryosong krisis pampolitika. Pero hindi po dahilan yon para kalimutan ang tunay na trabaho natin, ang maglingkod sa bayan. Ang hustisya pwedeng isabay sa serbisyo, hindi kailangang mamili. Pakiusap ko po, huwag nating hayaang matabunan ng ingay ng politika ang sigaw ng ordinaryong Pilipino. Habang pinagdidibatihan natin ang impeachment, may mga kababayan tayong inihintay ang gamot, dagdag sahod at ng pag-asa. Bawat araw ng delay, may nawawalan ng lakas ng loob. Bawat hindi pagtutok, may Pilipinong nawawala ang tiwala. Ilan lamang ito sa mga panukalang batas na naantala dahil sa usapin ng impeachment. Ito po ang panawagan ko bilang inyong kasama. Tulungan natin ang mga panukalang tunay na may silbi. Panahon na po para pakinggan ng bayan. Naniniwala po ako na ang pag-usad ng impeachment ay hindi makabubuti sa ating bayan. Ang ganitong hakbang ay hindi lamang nagbubunsod ng lalong pagkakahati-hati ng ating sambayanan, kung hindi isa ring sagabal sa patuloy na pagganap ng ating mga tungkulin legislatura, lalo na po sa Senado. Sa halip na ituon natin ang ating oras, talino at lakas sa mga panukalang batas at programang makatutulong sa pagbangon ng ating ekonomiya at kapakanan ng mamamayan, tayo'y nalilihis sa usaping hindi agarang dapat aksyonan. Napapabalita pa nga na bumagsak po ang ating net foreign direct investment inflows ng bansa mula Marso ngayong taon dahil sa political instability. Pati na rin po ang ating turismo sa bansa. Mula Enero hanggang Abril nitong taon, ang dami ng dumarating na turista sa bansa ay bumaba ng 0.82%. kumpara noong nakaraang taon. Lahat po ito political instability. Mga mahal kong kasama, ang impeachment na ito ay napakarami ding chismis, napakaraming iskandalo ng tungkol sa bayaran, sa alok, ng kung ano-ano. Dahil po dito, muli po, inihikayat ko ang aking mga kapwa lingkod bayan na bigyang prioridad ang pagkakaisa, katatagan ng ating institusyon at kapakanan ng sambayan ng Pilipino. Maraming salamat po.
Senator, what is the pleasure of Senator Judge Pimentel?
Since there is a motion, I think, Mr. President, and the motion is to dismiss the entire impeachment case. So this representation has no choice but to object to the motion. And if I can, just like the movement, if I can also now give my reasons, Mr. President.
The gentleman,
Before that, with the indulgence of the minority leader.
what is the pleasure of Senator Judge Cayetano?
Just to clarify the motion before we debate on it, because I heard Senator Bongo second, but he also stated that okay then i-remand. Because personally, I'm against the dismissal, but I would be willing to hear arguments on remanding. So I'm sorry, Senator Pimentel, I just want to know, is Senator Bongo actually proposing to amend the motion of Senator Judge Bato, and is Judge Bato amendable to that? Sorry.
No, Mr. President, I was not confused at all because
No, I'm the one who's-
Senator Go gave a seconding speech. So the motion stands. He is seconding the motion.
Pero yung laman, Mr. The reason I want to ask, because I will object with Senator Pimentel kung dismissal, but I will listen to the arguments kung remanding to the, no. So, may I ask,
With the
Senator,
permission
with
of
your
the Senator Judges to have the floor, may we hear from the principal movement? Senator Bato is recognized.
Mr. President, my motion stands. I am for dismissal of the impeachment case, and I don't know if I am open. I am open for discussion. I heard the statement of Senator Alan Cayetano, but still, I have already filed the motion, Mr.
So,
President.
Mr. President, so let me continue now. I made my objection, and if I be allowed, just like the movement who gave reasons, if the objecting judge can also give his reasons, Mr. President.
What is the pleasure of Senator Judge Villanueva?
Mr. President, this is to somehow give these representations point of view with regard to the pending motion. And as I made mention a while ago, Mr. President, I am also objecting, Mr. President, respectfully. But hope springs eternal, Mr. President. Bigla kong narinig yung binanggit ni Senator Alan and Senator Bongo. And if I'll be able to explain later after the minority leader, perhaps this representation would be able to encourage and influence the original movement of the motion. So I yield the floor to our minority leader, Mr. President.
Chair would like to save the time of the court, so the chair will in the meantime allow Senator Pimentel to make of record his position, presumably against dismissal. Thereafter, before entertaining
Against the motion.
against the motion, before entertaining other senator judges to speak, the chair will suspend the session in case the appeals made will change anything. So that we will pursue this matter and put a matter to a vote with certainty. Senator Pimentel may proceed.
No, I think, Mr. President, the motion has been made and this representation is objecting. So later on, we have to now process the motion and vote on it because there is in a collegial body someone is objecting. Mr.
Senator Pimentel, you may proceed.
Yes, Mr. President. I will not address the political statements of the movant and the seconding parties, Mr. President. Ang tanong nila kung makakain ba daw itong impeachment process, pero marami namang bagay sa buhay na importante rin na hindi nahahawakan. Tulad ng hustisya. Ang hustisya, hindi nga natin makita, hindi natin mahawakan niya, pero napakahalagang bagay po sa buhay ng tao. Ngayon, pagdating po sa konstitusyon, bakit inaangalan ko yung motion? The motion actually is unconstitutional, in the opinion of this representation, because according to Article 11, Section 3, Paragraph 6, per sentence lang yung babasahin ko, the Senate shall have the sole power to try and decide all cases of impeachment. So tignan natin mga fellow senator judges, sole power. So ibig sabihin ng sole power, tayo lang ang may kapangyarihan, ang Senado lamang ang may kapangyarihan na mag-try and decide. So litisin ang isang impeachment case at hatulan, desisyonan. Ngayon kung aayaw tayo kaagad ni hindi natin na-try, ang try is litis, palabas yung mga facts para ma-apply natin yung judgment natin sa facts, wala na pong matatakbuhang ibang body. That's why a motion which cuts short the entire process is unconstitutional. And then, same article, Section 3, Paragraph 4, basahin ko ulit ito, pero paulit-ulit ko na ito sinasabi when we were in legislative session. In case the verified complaint or resolution of impeachment is filed by at least one-third of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. I believe, and I think I'm correct, that the impeachment case against the Vice President falls exactly under the facts assumed in Paragraph 4. This is the articles of impeachment filed by at least one-third of all the members of the House. Lampas-lampas pa nga sa one-third of all the members of the House. Therefore, what should the Senate do? Trial by the Senate shall forthwith proceed. So, trial means we bring out the facts so that we can now apply what is the mandate of the Constitution. Mag-decide tayo given the facts. Should that impeached official continue to remain in office, or should that impeached official be removed from office? High-ranking government official. So kung makita po natin, in two constitutional provisions, andun yung word na try, andun yung word na trial. So wala po tayong choice but to respect, lalo na ito, we fall squarely under this subparagraph 4 which I just read. We have to respect the decision of the overwhelming majority of the members of the House of Representatives, more than one-third, because they are also the representatives of the people. If they find something worthwhile charging a high-ranking government official with an impeachment and impeaching that official, the Senate has no choice but to hold the trial. Bakit? Yung mga representatives ng taong bayan sa House of Representatives, gusto rin makita ng taong bayan, did they act properly? Did they act justly? Ano bang ebidensya nila? Ilabas yan. O kasi kung wala ring ebidensya, sinayang yung oras, sinayang yung resources, next election, lagot kayo sa inyong constituents. And then at the same time, a trial necessitates respecting the rights of the parties we are also respecting the right of the impeached official kasi kaya nga tawag sa kanya, impeached officer na siya eh. So, na-tarnish na nga actually ang kanyang reputation in public service ng House of Representatives. The trial will give that impeached officer the chance to clear his or her name and at the same time maybe rebuild his or her reputation, Mr. President. And then, since the presiding officer, when we adopted the rules, when he made the motion to adopt our rules, we did not only adopt our Senate rules on impeachment, we also adopted some rules of the rules of court and then some circulars and some amendments. In a court proceeding, ito by analogy, we are actually like a court. In a court proceeding, since the judge should observe the cold neutrality of an impartial judge, yung mga pagkakamali or pagkukulang alleged sa complaint, sa information, it should be the affected or aggrieved party which should raise that before the judge or before the judges in a collegial body. Yun po yung tamang kilos ng cold, neutral, and impartial judge. Let the parties point this out to us. Therefore, even if you want to entertain this, although ako sabi ko it's unconstitutional, we cannot entertain this. In the normal court processes, this may even be premature to entertain because let's await the answer to be filed by the impeached official. Tignan natin if she, the impeached officer, will point this all to us. And then, sabi ko nga, ang daming facts na kailangan natin malaman. Did yung mga 10 days, 3 days, and then it requires familiarity with the rules of the House. So, Mr. President, for all these reasons, I object to the motion, but my anchor argument is that it is unconstitutional. The Senate, as the impeachment court, cannot cut short the process by dismissing an impeachment complaint, Mr. President. Thank you.
Senator Ontiveros is recognized. You may proceed, ma'am.
Salamat po, Mr. Presiding Officer. I do object to the motion of Senator Judge De La Rosa. A motion to dismiss is not found. Hindi po nahahanap itong motion to dismiss sa Rules of Procedure on Impeachment na literal ka-adapt lang po natin. At kung mayroon man, hindi Senator Judge ang magre-raise nun, kundi ang defendant. Si Vice President Sara Duterte ang dapat mag-raise niyan. Higit pa po, naniniwala ako na hindi po tayo pwedeng kumilos unilaterally sa dismissal ng impeachment complaint nang hindi pa natin naririnig kahit isang salita mula sa prosecution, ni isang salita mula sa defense tungkol dun sa di umanong constitutional infirmities ng impeachment complaint. Ang due process ay nagre-require na bigyan natin pareho ang prosecution at ang defense ng oportunidad na madinig sa bagay na ito. Ang landmark Philippine Supreme Court case, ang Tibay versus Court of Industrial Relations, GR number L46496, February 27, 1940, ay inisa-isa yung mga essential elements o tinawag nitong cardinal primary rights ng due process, partikular sa mga administrative o quasi-judicial proceedings. Kasama po dito ang the right to a hearing, that the tribunal consider the evidence presented, that the decision must have something to support itself, and the existence of substantial evidence. The decision must be based on the evidence adduced at the hearing at wala pong panlabas o hindi totoong mga bagay-bagay ay dapat mag-impluensya sa outcome doon. Ang pinaka-basic tenet ng due process ay yung karapatang marinig. Kung yung mga parties nga po ay hindi nabigyan ng oportunidad lumahok sa proceedings, itong impeachment court ay magiging vulnerable sa isang atake na nilabag natin ang due process. At sa pananaw ko, sila'y magiging tama. Ang rekomendasyon ko po ay bago magdesisyon ang body na ito sa usaping ito, i-notify po muna natin ang prosecution at ang defense tungkol sa motion ni Senator Judge De La Rosa at bigyan sila ng sapat na magsumite ng kanilang comments sa bagay na ito. Gusto ko rin pong gawing off record, Mr. Presiding Officer, na batay sa pagkaintindi ko, yung alleged infirmities ng articles of impeachment ay kwinestyon sa harap ng Korte Suprema. Nasa Korte Suprema na po ang usaping ito. At wala naman pong TRO na ibinaba ang Korte Suprema. Mr. Presiding Officer, maintaining the view that the parties should comment on the question made before this body, para po sa akin, ang impeachment court ay dapat lamang po tayong mag-rule sa motion pagkatapos nating ni-require yung parties mag-comment dun sa motion ni Senator Judge De La Rosa within that sufficient period of time as the good presiding officer may determine. Pending this, minimaintain ako po, Mr. Presiding Officer, ang aking objection sa motion. Salamat po.
Thank you, Senator Ontiveros. What is the pleasure of Senator Judge Villanueva and thereafter Senator Judge Cayetano?
Thank you very much.
Senator Judge Villanueva, you may proceed.
Thank you, Mr. President, Presiding Officer. Nung sumumpa po tayo bilang mga senador ng Republika ng Pilipinas, ang sinumpaan din po nating tungkulin ay pag nagkaroon ng pagkakataon na magkaroon ng impeachment proceedings, tayo po ay tatayo bilang mga senator judges ng impeachment proceedings. Nung time po, Ginoong Pangulo, na tayo ay nung time po na ang House of Representatives ay dininig itong mga several impeachment complaints, natatandaan ko yung tatay ko, Ginoong Pangulo, hindi po siya pumirma. Not just because he doesn't believe in the impeachment complaint, but because he knows for a fact that his son will stand as one of the jurors, as one of the judges, Mr. President. Kaya po, nais nating panatiliin ang pinakamataas na antas ng integridad at pagkilala sa mga nagaganap dito po sa bulwagang ito. And having said that, Mr. President, this representation during the time when we have yet to convene the impeachment court objected to the motion because this representation believes that the motion should be filed in this impeachment court. Now, in this impeachment court, Mr. President, I am objecting because, let me quote again, Article 6, Section 3, Paragraph 4 of the 87 Constitution provides that upon the filing of a verified complaint impeachment by at least one-third of the members of the House of Representatives, trial by the Senate shall forthwith proceed. At ito ho yung dahilan kung bakit ang ating Senate President nagpagawa agad ng robes, pinrepair ang bulwagang ito, at hindi natin sinasabi, Mr. President, na mababaliwala yung mga binanggit ni Senator Bato, Judge Senator Bato, Judge Senator Bongo tungkol po doon sa impeachment complaint. Hindi din po natin binabaliwala at kailangan talagang mapag-usapan natin yung tungkol sa one-year ban, yung pong tungkol sa jurisdiction ng impeachment court to make sure that the representatives representing the House of Representatives shares the same intention as the 19th Congress, ito pong 20th Congress ng HOR. Number 2, Mr. President, yung Article 6, 11, Section 3, Paragraph 6 na binanggit po kanina ng ating Minority Leader. Ang Senate's role is to try and decide all cases of impeachment. Kaya po, sa totoo lang, Mr. President, tinignan ko yung konstitusyon, hindi ko po makita kung binibigyan ng authority ang Senado para i-grant yung to summarily dismiss, Mr. President, ang isang impeachment complaint. The power of initial determination belongs solely to the House, ang Senate magta-try. Mr. President, nung pong panahon ng impeachment ni then Chief Justice Corona, may motion po during the trial yung second day wherein the defense challenged the validity and legality of the proceedings. And in connection with the initiation of the impeachment complaint of the House of Representatives, the defense argued that the verification of the impeachment complaint was fatally defective and should thus be dismissed. Ang impeachment court po ruled in favor of the prosecution on the said motion, and arguing that the impeachment complaint was made in accordance with paragraph 4, section 3, article 11 of the Constitution. So, yung defective, na fatally defective, kanina nabanggit po, kaya po ako nabuhayan ng loob dahil may nabanggit po kanina si Senator Judge Alan Cayetano, Senator Judge Bongo, tungkol po doon sa checking yung House of Representatives. Kung sila ba ay interesado pa, kung sila ba ay naniniwala na tatawid mula sa 19th to 20th Congress ang impeachment na ito, kailangan po natin makita ito at malaman. And if that is the motion, Mr. President, I am more than willing to support that motion because para sa akin, and this is my own personal opinion as a senator judge, hindi po madidelay ang impeachment trial. Hindi po maaapektuhan ang impeachment trial sapagkat ibabalik po natin sa kanila at sasabihin natin, meron ba itong verified complaint na ito? Ito ba ay inyong sinusuportahan pa rin sa 20th Congress? So, Ginoong Pangulo, for that reasons, I would again reiterate my objection to the motion to dismiss, Mr. President. Thank you.
Senator Cayetano.
Sir President, I take this podium in the hope that after I speak, Senator Judge Bato will get behind my idea, or the idea eloquently espoused by Senator Joel Villanueva. Sabi po sa Section 88 of Rule 30 of the Rules of the Senate, the sponsor or any motion or measure, the sponsor of any motion or measure may withdraw or modify it before its amendments or resolution or before a nominal vote is ordered on the same. Before Senator Pimentel, Senator Judge, Minority Leader Pimentel spoke, clarify lang po ni Senator Bato that he's standing, itutuloy po niya yung motion, and I think hindi niya kinonsider ng motion to amend yung statement ni Senator Bato. But after hearing Senator Bongo, after hearing Senator Joel Villanueva, after hearing the Majority Leader and Minority Leader, I ask you for some patience. Just hear me out on a very practical approach to this. No? You know, every time I'm confused or di ko malaman yung sagot, I go to Jeremiah 29:11 that states, "For I know the plans I have for you, plans to prosper you and not to harm you, plans to give you a hope and a future." But I'm reminded that kung ang Diyos may plano sa atin, ang demonyo may plano din sa atin. So, one way or the other, we have to make a decision today. And it has to be the right decision. So, ito yung very practical approach ko po. We can do three things. We can dismiss it today. We can remand it to the House of Representatives. Or pwede natin ituloy bukas. If we dismiss it today, based on the ground that it is violated the Constitution at more than once na po ito na-file in 1 year, we don't have enough time today to debate that. As the Minority Leader said, yes, we can take judicial notice of the dates, pero I wanna see the documents. kailan ba talaga nag-file, sino final, etc. So aabot tayo bukas and even tomorrow with 23 opinions dito. My point is, Mr. President, I cannot in conscience, as a lawyer and as a senator judge, just make that rash decision that it violated the 1 year. I mean, ngayon ko lang nalaman na pwede yan, or if we were thinking about it the last few days, pero ang Supreme Court nakailang araw na, nakailang linggo na, hindi rin nagdedesisyon pa. So, mabigat tong puntong ito. That's my appeal to Senator Bato, na mabigat desisyonan ng dismissed based on it has not been filed, that we violated the Constitution na mahigit isang beses tong final. Yes, may mga Supreme Court decision. That's why I'm ready to consider it. Kung wala kasing Supreme Court decisions, walang mag-guide sa atin eh. Kung unang beses to na hinaharap natin ng impeachment at 4 ang final, whatever we decide, pupunta sa Supreme Court eh. Pero ilang beses na to pumunta sa Supreme Court eh. So meron ding guide, but do we have enough time right now? Second po, handa ba ang prosecution? Ang makakasagot lang po nun, not even the re-elected prosecutors. Remember po, magkakaroon pa ho ng session sa umaga ng SONA sa July. At mag-e-elect pa ng speaker. And based on that, i-confirm pa nila kung itutuloy nila to o hindi. Of course, by all indications now, itutuloy. But why will I assume that? Why will I also assume na 4 yung final? Hindi ko nakikita pa yung lahat ng dokumento. Pero lahat ng briefer nandito. Kung talagang kailangan mag-decide today, they give us a few minutes, we'll take judicial notice or ask our very able secretariat. No? The third is that hindi daw pwedeng tumulay sa 20th Congress. Pero lahat tayo po ay nag-agree na hindi natin mapipigilan ang 20th Congress na i-take up to. So, bibilisan ko na po if we dismiss it today, pwede ba mag-file ng motion for reconsideration yung prosecutors? If yes, kailan nila ipapile to? Tomorrow. Kung hindi tomorrow, sa 20th na to. So, all the arguments na sinabi ni Senator Bato, totoo din, dun na yon. Okay. If ituloy naman natin tomorrow, babasahin yung articles, bibigyan ng 10 araw, mag-issue ng summons, bibigyan ng 10 araw na sumagot ang akusado or yung the Vice President has been impeached, and then pwede yung prosecutors 5 days, aabot na tayo ng June 30 nun, hindi pa nagko-convene ang 20th Congress until the day nung SONA. So, in both cases, dismissed or tuloy, dun pa rin tayo magharap eh. Ano po ang benefit ng pag-remand? Again, excuse me everyone sa legal, moral, because I only had a few minutes to think about this. Kung sana si Senator Bongo ang nagpa-amend, I was willing to listen. Pero hindi daw yon amendment at hindi tinanggap ni Senator Bato. So ako nagmumove ngayon na i-consider ni Senator Bato, i-amend yung motion niya from dismissal to remanding. No, I cannot move myself na i-remand because may pending motion now. But I can ask him to amend his motion. And why will remanding be in the interest of justice and consistent with our oath of political neutrality? Kasi ang mangyayari nito, hindi pa binabasa yung articles of impeachment bukas, babalik to sa House of Representatives. Hihingin natin ngayon na isa-certify nila na hindi nila violate yung 1 impeachment per year. Number 2, by the time they answer sa 20th Congress, prosecutors na ng 20th Congress ang mag-affirm na interesado kami na itutuloy namin to. And by that time, the 12 senators po who have joined the 20th Congress will have the wherewithal and the say-so how to proceed. So, I'm just looking from it from a practical point of view. It might not sit well with my colleagues. If I wasn't a lawyer, perfect yung aking pong sinasabi. But being a lawyer, kailangan ko rin pag-isipan. Pero tignan niyo lang po from a practical point of view. Pag dinismiss natin to ngayon, maibabalik din nila, Senator Bato. I-file din nila. Pagka naman hindi natin dinismiss, doon din ang mangyayari. Pag niremand natin, may mangyayari. May malalim na pag-iisip ng mangyayari dito. That's why I'm asking Senator Bato if he will, again, consider amending his motion.
Mr. President, because in the course of the manifestation of Senator Alan Cayetano, he mentioned that the minority leader is somehow encouraging judicial notice.
No. I mean,
Can I state my position?
No,
Actually,
Senator,
we
I was agreeing with you that we cannot decide. We cannot
take judicial notice
I said, yes.
of all those facts being alleged. We cannot. That is my
I think
position.
Senator
just want to
Judge
make-
Cayetano agreed with
Yes,
you.
yes. I
Senator
said,
Judge Pimentel.
even myself, I am not in favor of taking judicial notice kahit may magsabing pwede. I'm sorry, Minority Leader, if it made it appear that I'm speaking for you. I'm agreeing with you na mahirap mag-decision ngayon on dismissal based on the grounds na binigay sa atin nila Senator Bato and Senator Bongo and our other colleagues.
To clarify, before I recognize Senator Bato, the chair, as it understood the point raised by Senator Cayetano, is that the basis of the two grounds raised by Senator Bato in seeking a dismissal
Three grounds, Mr.
Three grounds.
Presiding. Yeah.
cannot be taken judicial notice of by the court, and that these facts must be obtained, if at all and or ascertained, from the parties involved. In this case, the House prosecutors and the 19th Congress members who signed. That is the understanding of the chair with respect to the statement of Senator. Senator Bato is recognized. Senator Judge Bato is recognized, rather. You may proceed, sir.
Thank you, Mr. Presiding Officer. Before I comment on the manifestation of Senator Judge Alan Peter Cayetano, I just would like to react on the manifestation made a while ago by Senator Judge Risa Hontiveros, that the Senate as an impeachment court has no power to dismiss any impeachment complaint. I would just like to share to the body, Mr. President, that the power of the Senate to try and hear an impeachment complaint necessarily includes the power to dismiss the complaint. This is basic, that the grant of express powers includes the grant of incidental or necessary powers. We apply, by analogy, the principle of competence in German and competence, de la competence in French, which is indeed a major part of incidental or inherent jurisdiction of any judicial or arbitral tribunal. It is necessary component in the exercise of the judicial function and does not need to be expressly provided for in the constitutive documents of those tribunals. Kaya Mr. President, kahit hindi ako lawyer, masasabi ko, if this impeachment court has no power to dismiss an impeachment complaint, walang silbi itong korte na ito, Mr. President. That's my opinion, Mr. President. Ano bang gamit ng korte na ito kung hindi inherent yung power niya to dismiss? So that's my humble legal opinion, although I am not a lawyer, Mr. President. And Mr. President, going back to the manifestation of Senator Cayetano, sometimes I am contemplating that how I wish Senator Cayetano is always present in the floor. Every time a crisis is being faced by this August chamber, Mr. President, because his ideas and his mere presence only can cool down the boiling hearts and heating heads. So with that, Mr. President, I would like to ask for a 1-minute suspension because before I made my final decision on the manifestation of Senator Cayetano, I would like to confer with my co-movants, Mr. President. Baka iinit naman ang ulo nito mga kasamahan ko, Mr. President. Thank you, Mr. President. 1-minute suspension.
Session is suspended.